Hello and welcome to the Our Prenup Lawyer podcast, where you and I get to learn more about prenups as I interview professionals from the fields of family law, couples counseling, and wealth management. I'm your host, Libby Garabedian. Let's get started. The information provided in this podcast is prepared by Our Prenup Lawyer for informational purposes only and does not constitute legal advice. The information is not intended to create an attorney-client relationship. This is not legal advice or a substitute for obtaining legal advice from an attorney. A person listening or watching should not rely upon it in any manner without engaging professional counsel. The podcast is intended to communicate general information and, because recorded, may not be current. On this episode of Our Prenup Lawyer, I'm joined by Ankit Kapoor. Ankit is a founding partner of the New York-based boutique law firm Cohen Stine Kapoor LLP, where he focuses on high-stakes matrimonial and family law matters, including complex custody disputes and high-net-worth divorces. Before entering private practice, he served as an officer with the New York City Police Department, bringing to his legal work a disciplined, real-world perspective. He earned his BA in Political Science and Government from Hofstra University, then obtained his JD from Brooklyn Law School. While continuing his service in the NYPD, fluent in Hindi and Punjabi, he offers personalized counsel to a diverse clientele, including individuals navigating surrogacy and assisted reproductive technology issues. Welcome. Thank you so much for being on the episode today.
It's an honor to be here for this episode.
Thank you. Let's go ahead and jump right in. Tell me about your career and how you entered family law.
Sure. So a lot of people don't know I was a police officer in the NYPD for 7 years before I became an attorney. I attended law school part-time at night while being employed full-time by the NYPD. Went to Brooklyn Law School, great law school for anyone that's considering law school. And after I graduated, I was working for the New York City Law Department. I was actually doing tort defense. I was defending city employees, including police officers, firemen, sanitation workers, and other city workers. And I would appear in front of the same judge on a week-to-week basis. And she took a liking to me, and she asked me about my aspirations. And I said, I actually want to be a matrimonial lawyer. And I wanted to be a matrimonial lawyer because I think it's recession-proof. Also, you deal with two of the most important issues to every human outside of their health, which is their children and their money. So this judge introduced me to my now current partners, and I got hired as an associate. I eventually made partner, and that's like the long story short as to how I ended up where I am.
That's great. What was the transition like? Obviously, you're going to school at night. You're still balancing your career in the NYPD. What kind of skills do you think are transferable from your previous career to now?
I think listening to people is definitely a skill that has been transferable, as well as interviewing, because as a lawyer, you should be asking a lot of good questions. The lawyer's job is issue spotting the issues and figuring out a way to resolve them. I did a lot of that as a police officer, where someone calls 911, you show up to a job, you ask them questions, what happened, who did what, and you gather information. So those skills were extremely transferable.
So what kind of attorney would you characterize yourself as?
I think I've never characterized myself as an attorney. I'll tell you what I have been characterized as. Aggressive, caring, sympathetic, empathetic, uh, a killer trial lawyer. So that's how I've been characterized. I don't know which one of those things are actually, how applicable each one is, but that's what I've been told.
So what's your philosophy on divorce?
It's a tough question. I don't come from a divorced family. My parents have been together for 37 years. My philosophy on divorce is try until you can no longer try. So I'm a big proponent of people actually staying together to the extent that they can, and not just for the children, but for themselves. I think often in life, we give up on things too easily. So when I have a potential client that comes in, I ask them, have you tried couples counseling? Have you tried individual counseling? You know, they're not everyone that comes into my office is ready for a divorce. So in those cases, I'll recommend something such as a postnuptial agreement or even a trial separation. And you know, sometimes they come back every now and then, but I have saved a couple of marriages, at least for the time being, by doing a few postnup agreements. So that's my philosophy on divorce. Try until you can't. Try, you know, being in your marriage until you can't anymore.
So with having this perspective on divorces, trying until you can't anymore, and working with the couples on a postnup, what does that look like to try to set up a different future or goals for their marriage?
Both. So a postnup is a prenup after the marriage. And it basically outlines what will happen in the event that there's a divorce or if there's death. All marriages end in two ways, either death or divorce. And both a prenup and a postnup can outline what happens. And it's, you know, it's people come to me for a postnup when something catastrophic has happened in a marriage, and it's typically infidelity or there's some sort of abuse and a party is not ready to get a divorce. Or maybe the children are in junior high or high school and they want to wait, or they want to give it some more time before they actually get divorced, but they're looking for some security. And a postnup kind of takes the uncertainty away as to what may happen in the event of a divorce. So people look for that in a postnup.
Okay, so when someone is ready for a divorce, what is a typical timeline for their litigation?
I I would say that varies from state to state and county to county. In Manhattan, a typical timeline is 2 to 3 years in high conflict, high asset divorces. I just finished a trial yesterday. That divorce was commenced in December of 2022, and I finished, and we didn't get to trial until September of 2025, and we finished it in November of 2025. And it was 16 days of a financial trial. It does not even include custody because custody was resolved. So the timeline of a divorce varies from state to state. I've settled cases in 6 months, but that's rare. That's very rare. In New York, in Manhattan, Brooklyn, these kind of counties, even Nassau, Suffolk, Westchester, I would give around a 2 to 3 year timeline.
Okay. When you have these high conflict, high asset divorces, what kind of curveballs do you run into as an attorney when you're trying to, advocate the best for your client?
Curveballs, oftentimes, let's say you have a case, it's a $10 million asset case, for example. And my client will tell me, well, you know, that 2 million in that account, that's actually pre pre marriage. This from prior to the marriage. And I now have to gather records, if the client even has records, to be able to prove that this account is from prior to the marriage, and that the burden is on me to prove that in that case, because the presumption is all property is marital property, and or all property accumulated during the marriage is marital property. But what can happen is, you know, a grandparent can pass away during the marriage and pass down money to their son or daughter, and that account, for example, if it's a brokerage account, it's kept separate. But I have to prove that. I have to get bank statements from my clients. I have to have a forensic analyze them to make sure money from like that was earned during the marriage wasn't put into that account. I have to figure out whether that account was commingled, because just because it's a separate property or maybe a separate property account doesn't mean it retains that character throughout the marriage. It depends on the conduct of the party.
Right. So when you're dealing with aspects of estate planning, a prenup alleviates a lot of stress, or from your position, excuse me, if these terms are outlined and the couple is following it to a T.
Yes, one thing to keep in mind is under New York law, inheritances are your separate property, even if you don't have a prenup. Um, a prenup can further define what separate property will be. For example, earnings during the marriage. You make money. If we're married and we're earning, I'm working as a lawyer and you're working as a doctor, whatever. But the earnings are all marital. But in a prenup, you can carve that out that it's not marital, it's going to be separate. And in New York, especially where title does not control. So if something's in my name, doesn't mean that I get to keep it in a divorce. Title is not determinative under New York law. So in a prenup, what I like to do what's called a title regime prenup, where the whoever name is on that account, that's theirs. And if anything's in joint name, that's going to get divided up, whether it gets divided up 50-50, 60-40, 70-30, whatever the case may be. You can put all of that in the prenup.
Okay. In drafting a prenup, what has been the pettiest thing that a client has asked you to include?
The pettiest thing, it was I don't know why the other side wanted this, but she wanted to know the names of the women that my client had been with during their relationship, and she put that in the prenup. And it was part of an infidelity clause, which are generally not enforceable, but they insisted on, one side insisted. And that was one of the petty things that I've seen in a prenup, to put the names of, like, why would you want to know? But I think, I mean, my speculation is down the road, if something happens and they have kids, that she would show that prenup and the names of the women to the kids and say, look, this is what your father had done. And that's my pure speculation, although we did put a confidentiality provision in the prenup. And it would, with celebrities or with high profile individuals, we always have confidentiality provisions where there's certain carve outs. So you can show it to your lawyer, you can show it to your accountant, you can discuss it with your therapist, but you can't go into the public with it. You certainly should not be showing your children with it, but people are human beings. They're going to do what they want to do.
Right. When you're dealing with, people of a high net worth, or even individuals who ask for some unique provisions in their prenups or postnups, how do you counsel your clients so that it doesn't become an adversarial process in their marriage?
Well, the number one thing I say to them is, have you discussed this with your spouse? And before I send this to your spouse's lawyer, please discuss it with him or her. Make sure they know that this is what we put in it, so that it's not a shock when they receive it from their lawyer. Because that causes a lot of problems, because the other spouse will say, we never discussed this, we never talked about this, I can't believe you put that in there. And then the blame will come on me. Well, my lawyer said it was a good idea, which sometimes could be true, but I like open communication. When I'm doing a prenup or a postnup, everyone needs to be on the same page about the goal that we're trying to accomplish here.
Exactly. Now, I want to switch gears a little and talk about reproductive issues in marriages. Now, does a couple need a written contract with their surrogate?
Yes, so surrogacy in New York has become legal recently, gestational surrogacy, where you have a third party carry the child outside the couple. It could be a heterosexual couple, it could be a homosexual couple. And you definitely need a contract, a surrogacy contract. The couple needs to be represented by counsel. The surrogate needs to be represented by counsel. And the contract has to outline all the terms of what's going to happen with this pregnancy.
And how long does the contract extend? Does it last just for the gestational period, or does it precede it and follow it?
It can go as long as a year after their pregnancy. It's whatever you agree to. Postpartum care. Maybe you put them in a hotel. You provide medical insurance. You pay for all unreimbursed medical expenses. You pay for medication. I mean, it's whatever you decide to put in the contract, but it anywhere from like 6 months post birth is like the typical timeline, or up to a year.
Okay. And alternatively, in New York, if a couple has embryos together and they get divorced, what happens to those embryos?
Okay, so typically what happens with the embryos is controlled by their contract with the fertility center. However, I have done a prenup where the couple had pre-existing embryos, and my client said that if he passed away, he wanted the embryos destroyed. I don't know what the contract with the fertility center said. I can't remember it. But you can negotiate out of it in a prenup if you wanted to do that. But typically the embryos get destroyed if there's a divorce.
Okay.
And you can't, and typically one party can't go to the fertility center and say, I want to use those embryos. You have to have both parties consent. Typically, you can contract out of that, for example, in a prenup. Whether the fertility center will honor that contract, I don't know. I haven't come across that issue.
Okay, so we have the separate third-party entity of the fertility clinic that does control a lot in these agreements.
Yes.
Okay. What have you run into in custody disputes that makes it more difficult in proceedings to come to an agreement? And alternatively, what, I guess, collaborative processes help couples set up a parenting plan or visitation for their children?
Sure. So parenting plan, custody, visitation, the complexities vary depending on the age of the children. I'm doing a case right now in which I represent a physician and the child is only a year old. Okay. And custody goes until all the way to age 18 in New York, and child support goes all the way to emancipation, which is age 21 in New York. And navigating what the custody visitation looks like for a 1-year-old is very difficult because the child is still breastfeeding. The child cannot be that away from the mother for a prolonged period of times. Typically, of course it varies. And so figuring out what the access schedule will be when the child is 1 versus when the child is 3 versus when the child is 5 and going into kindergarten or first grade versus when the child is approaching junior high, that's very complex. Typically those type of agreements, if we did an agreement with the child is 1 year old, we put in a step-up access schedule, but it may not always work out that way. We don't know what's going to happen. We don't know what the relationship of the child is going to be with each parent. Maybe you put up a step-up access schedule up to a 50-50 when the child turns 8 or 10, but the child doesn't want that. So those are issues I run into with young children. With older children, let's say ages 8 or older, or even 7 or older, they're able to articulate what they want. The court sometimes appoints a lawyer for them, and what they want may conflict with what a parent wants. And that's when you end up in a custody litigation, which is very expensive in New York. And I've tried many custody cases. I've examined forensic psychiatrists who evaluate a family when there's allegations of abuse or mental health issues. I have dealt with cases where the child is saying, I only want to see dad every other weekend, and the dad is saying, no, that's my daughter. I want to be with her at least 50% of the time. I'm just as much as a parent as a mom is, which is true. So I've tried cases on those issues. And custody litigation, again, it varies from family to family, from child to child. Age of the child is very important.
Now, you've worked with high net worth individuals and dealt with high assets. Obviously, like you said, each litigation is different, and depending on what a couple is looking for, there's a lot of variation. Now, can you share with us any notable outcomes or divorce solutions that you've had for your clients in the past?
Okay, so I represented a very sophisticated client recently. She was the wife of a prominent hedge fund manager in New York City, but my client was also worked in hedge funds years ago. She was a very sophisticated, very intelligent woman. And when you're representing people, when you're representing someone and there's a hedge fund asset at issue, it gets very complex. You definitely need a forensic accountant to help you navigate those issues. And it's in that particular case, the marital estate was about $100 million outside of the value of the husband's partnership in the hedge fund. So whether she got 50 million or 30 million out of the 100 million was not going to drastically change her life. And she acknowledged that. So she took a portion of the 100 million, okay, and she left the husband's hedge fund interest alone because she, being very smart and very sophisticated, and also knows how to multiply dollars, right? She knows how to grow 30 million to 60 million. She said, I'll take, for example, let's just say it was 40 million. Okay. I know I'm entitled to at least 50 million, but I'll take the 40 million and I'll walk. I know how to turn that 40 million into 80 million. And that was a creative solution for her, for what she needed. She wanted to move on. I, as the lawyer, of course, told her what her rights are, what she's entitled to, but she just wanted to move on with her life. And I applauded that. And we were able to resolve the case without having the hedge fund interest valued, which is very difficult to do. And I can't get into why right now, but it's difficult to value a hedge fund interest because you don't know how certain investments may do in the future. It's speculative. You could do it based on past performance, but again, when hedge funds invest, so what they invested in the past may be entirely different than the industry they're investing in the future. But there are ways to come up with creative solutions when you're dealing with a very high asset divorce.
It's really interesting that she, had that perspective and that you took that approach to it, because obviously that's not very common for individuals to just, take less than what they're entitled to.
That is absolutely true. In fact, there's a decision that just came out maybe a month ago here in Manhattan where the marital, and I didn't represent either client, but I know the lawyers that did. The marital estate was 180 million, and I believe it was like a 20 or 25-year marriage. And the husband had put about 90 million or so in like these trusts, but they were created during the marriage with marital money. So he said that money is in trusts. So we got what's left over is like 70 million. I forgot the exact numbers. So he said, I'll give her the 35 million and I'm keeping the other 35 million plus everything in the trust. I can't access it anywhere. And the court, so the wife said, no, I don't want just the 35 million. I want my half of everything that I'm entitled to from the marriage, which was 90 million from the total 180 million marital pot. And they went to trial over that. And she ended up getting essentially $90 million. Now, would her life be that much different with 35 million versus 90 million? I truly, truly don't believe it will be, because there comes a point in your life when you have a certain amount of money where everything is accessible. And that number for me really would be around, I would say 10 to 15 million, maybe 20 million. When you have $20 million, you can go buy that $500,000 watch that you want. You can go into Cartier, buy whatever you want. You can go to Hermes, buy whatever you want. You can fly private if you want. You may not be able to buy the private jet that you want, but you can certainly get a NetJets membership and charter jets at any point. You can fly first class. You can stay at the Four Seasons at the Ritz-Carlton. So you can do that with 10, 15, $20 million. You can have a complete life of luxury. Some people do it with less. But after that, her fighting for the 90 million, which I applaud her. She's entitled to it. Okay, she is. But her life's not, I believe it was a matter of principle and not a matter of money.
Right.
So there are people that fight for what they're entitled to. And hey, I applaud them. If you have the wherewithal to do it, and I mean, 180 million, there's certainly enough money to pay lawyers to try a case like that. A financial trial, I just did a financial trial. It cost my client probably close to $2 million.
Wow.
From not the trial itself, but the preparation and everything that happened prior to the trial. So if you have the money to do it, to go for what you believe you're entitled to under the law, and you want to fight for it, and you don't want to cave in on certain issues, then go ahead and do it.
So what can people do to protect their interests and prevent an ugly divorce?
You get a prenup. That's a way to prevent an ugly divorce. And I'll give you a tip. if you don't have a prenup, or you believe you don't believe in prenups, or maybe you believe in a prenup and your spouse and your fiance does not, what you should do is you should save every single bank statement, account statement as of the month of the date of the marriage. Okay, because bank records only go back 7 years, and you may get divorced in year 10, and you may say, well, I came into the marriage with that $1 million or whatever the number may be, but you can't prove it. So, but if you have the bank statements, you can say, look, this is what it was on the date of marriage or the month prior to the marriage. So save those bank statements. And during the marriage, I said title does not control, but try to keep things separate as possible. If you get an inheritance, don't put money that you earned during the marriage into that. Keep it entirely separate. So those are a couple of tips that I have for people to try to prevent an ugly divorce. But outside of a prenup, it can be difficult to avoid an ugly divorce if you're dealing with a high asset case.
Right. So taking those extra steps to ensure those financial records, essentially.
Yes, exactly.
Well, I want to thank you for your time today. It was great talking to you. And what is your website so people can reach you in case they're interested in connecting?
Sure. So my website is csklawny.com. The law firm is called Cohen Stine Kapoor LLP. You can connect with me on LinkedIn. That's my name, my full name. And then if you want to connect with me on social media, my Instagram handle is New York Divorce Lawyer. No underscore, nothing, no numbers, just straight New York Divorce Lawyer. Facebook, I don't really post much on Facebook, but I am now being a little bit more consistent with it. So that's, again, under my own name. And you can find me there. Those are the ways to connect. And if you want to listen to other interviews I've done, that's available on YouTube. It's also available under media on my law firm website.
Great. Thank you. That's our show, folks. Thank you for listening to Our Prenup Lawyer. Make sure to like and subscribe, and feel free to drop a comment below. Follow us on Instagram at Our Prenup Lawyer, and listen to us on Spotify, iHeart, Apple Podcasts, Audible, and watch us on YouTube. See you guys next time.